Yeah.
You start when you get there. Meeting. नहीं आएगा मेरी
Yes. Yeah. Or yes. Oh. Yes. Okay. So you have complied with office objections. Learning counsel for the appellant submits that the office objections have been complied with. Let the appeal be listed for orders on consideration of IA number 1 of 22 and 2 of 22, as well as IA 1 of 21. Each date next week, Monday, 9th January. Number 2. Yes. Rectification, office objection. Who is filed? Let office objections, if any, be. Let office objections be complied with by the counsel for the impleading applicants. Within 1 week, list thereof. Notice already. Yes. Or on year number 2, 3, and 4 should notice to proposed LRs of disease respond number 7. 3. Yes. Fine. Content to enable learned counsel for the applicant to take steps for substituted service. Substituted service on respondent number 3A and C. Yes. Okay. I'm filing. Each time granted to the Bye. How much time? Week.
Both cases that against letters
I'll grant him a week's time. Learned counsel for the appellant prays for him granted a week's time to enable him to move an application seeking substitution of LRs of diseased appellant.
Yes.
Mr. Ganpati, but learned counsel for respondent shall be at liberty to file the documents if so advised. Next time. On filing of, yes. You're not filing of. Who is appearing? Password? who has filed these applications? Not there. We'll pass it over. Yes. Objection. We don't know. Mark, there presents none for respondents awaiting appearance of learned counsel for respondents. Hearing is deferred. List next week.
I appear for the appellant in this matter, my lords.
All right. Yes.
Appear for the appellant in this matter. I filed this memo.
None has, right. None has appeared on behalf of the respondent, though she or he, she has been served. She has been served through paper publication. Accordingly, memo is accepted. Respondent is placed expert. So, what are the record is there?
Yes, yes.
Appeal is admitted for hearing. Let the same be listed for final hearing. Yes, admitted of the honor. Then say, let the appeal be listed for final hearing. Weeks time, 2 weeks time, redemptory. Redemptory, Mr. 2017 matter.
Permission to retire.
And then dismiss. Right, Mr. N.K. Ramesh, learned counsel has filed a memo seeking leave of this court to enable him to retire from the case. He is permitted to do so. None has appeared on behalf of the appellant. It appears appellant is not interested in prosecuting the appeal. Accordingly, the same is dismissed. How much time? 2 weeks time. Redemptory. Redemptory, Mr. Yes. How much time? Weeks time. Weeks time is granted to comply with office of. Punishing of weeks time. Comply with office of. Sir, what dismissal for default or what? Heard on IA. 1 of 21. Reasons. Like number so and so 7 of 21 is restored to 5. Let the appeal be listed. What is the law? On revival, the interim order continues, right? We need not say. You better focus on admission. We will list it for admission. Yes. Filed a memo seeking leave of withdraw. Why?
And to prevent that further.
No, what?
And they are some maybe sir. The movement is to get an order, and then when they get you have to give to the hospital. And very far between this. Clear attempt of meeting her husband to be rehabilitation sector as preferred by the petitioner by filing this petition. There has been a report of the court of the score saying that there is a report itself, the admit that regularly consumes alcohol. And then that's the reason when a writ of habeas corpus has been issued by the petitioner, why do you and as the petition of false complaint, I need to place a written report to consider
No,
this.
so that I mean, you can't, you are opposing withdrawal of the petition.
So that of
No,
course, there is
the tenure, I mean, is at liberty. I mean, whatever, if you want to get her admitted, do so.
so there is not to correct the president, and there is also direct.
No, not direction means how,
Right, my submission
who is this petitioner? Mother,
He was against his will, he was kept in hospital without his consent and
who
approval.
has kept him in the hospital?
Then he was kept in hospital
By whom?
The tenure and his
I don't-
in-laws house. So my lords,
Who is detained?
husband of the mother of the petition.
Detained is the son. What's the problem? So if you have any cause of action, do it, file a petition, do whatever. We will grant you the liberty. No, we want to understand what I mean. Are you opposing withdrawal of the petition? Why? Can,
Based on the petition filed by the petitioner, he has been released from the hospital, and there has been over case and cases party. Now the my petitioner brings the and secondly, why it is also entitled to leave a
no,
life.
so what happens if this petition is kept pending, you will be safe?
That's the-
We want to understand. You are a respondent, you want a protection, file a petition. If your life is under threat, do whatever, take a recourse to law. What is in his petition?
not why petitioner has misused and
We don't, we are yet to understand how he has misused, how she has misused the jurisdiction. You have not been able to tell us how she has misused.
false criminal complaint filed against the husband of the petitioner.
So in his petition, that false criminal contempt cannot be quashed. If you want questioning,
So this order, he has been released. And
who has released for the, not getting, not who has released him from the hospital? This court directed
yes,
that,
correct, yes,
huh? Who is the detainee? Who is the, she is the person,
wait,
wife of the, where is detainee? So was he held hostage by the hospital? Huh?
no, that the hospital is here voluntary.
No, my lords. There was
And
no
he
one.
himself is saying, so commissioner, that said,
You are unable to, I mean, please tell us, what are the facts? What has happened? Who has admitted somebody in the hospital? Who has admitted? Police, you admitted. Petitioner. Petitioner is the mother. Hospital. So now he has been discharged. So you can, you want him to be in hospital, right?
yes,
Huh?
yes.
You admit him. What is this?
Before the false complaint.
What is this?
Why? First person to take care of the husband, and she has been prevented from at least taking care of the husband.
What is the statement made by the husband against the wife? Do you know? You know what is the statement made by the husband against the wife?
Correct. He says, he's not interested to continue.
Not only that, he also has said that she has got some illicit relationship and when the complaint was made, she has kept him in the hospital. That is the complaint.
Complaint started by the mother.
Whatever it is, that is the allegation by the husband. Husband says his wife has got an illicit connection with somebody, and when he approaches and fights against this, he has been kept in the hospital forcibly. We do not know, Mister.
No, that
We
is
do
the
not know.
scope.
That is not the scope of the petition. That is not the scope of the petition. That is the allegation made by the detective against the wife. Do not know, Mister. He has made this statement before a commissioner who was appointed by this court. That is the statement. It's not the scope of the petition, Mister. You should understand that. If you have got any dispute inter se, please go and fight it out in separate
Whatever.
forum, not here.
And by the order of some
How can in his petition of protection, what protection has been given to you?
wait and wait, wait and father. He has been directed not
No,
to-
we will grant you the liberty, Mister. We will grant you the liberty to take recourse to such remedy as may be available to you in law.
End of the we simply permit them to withdraw that is it.
No, there's no need to consider your application since the petition is being withdrawn.
Almost.
Yes. This,
Made one
the petitioner has filed a memo seeking leave of this court to withdraw the petition. Even otherwise, the detainee, who is a major person aged about 30 years, has stated before the commissioner appointed by the court that he has been detained against his wishes in the hospital. Full stop. He has since been released. Full stop. Even otherwise, nothing survives for, therefore, nothing survives for adjudication in this writ petition. However, needless to state that the parties shall be at liberty to take recourse to such remedy as may be available to them in law with regard to their grievances, if any. Pending it, three applications are disposed.
Like the police, during the course of police week of training of 100, part of this they should not, the observation that they should not be getting influenced by the either the income or the kind of other communicate. Since we have been released pursuant to the order of this.
You do whatever you want.
Parent institution may be directed. Yes,
In a petition filed for seeking a writ of habeas corpus free and fair petition at the instance of a person who is not a party to the writ petition. At least it defies logic. Yes.
it is filed by the other. Part of this.
Do whatever you challenge that free and fair. If it is not being held, we have said that it's open to you to take recourse to all the remedies. So challenge if it is according to you not free and fair. Challenge it on whatever grounds. Yes. That's it. Enough of it. In a petition which is being withdrawn.
Order directed against the detainee. That affidavit is not signed by the party, and that has been placed.
No. Detainee is a person aged about 30 years.
Yes,
Major, he has given a statement to the court commissioner that he does not have been detained in the hospital against his wishes, right? That's it. So what affidavit and all this? Do whatever, you file a petition, do whatever.
Appearance of this court has not been completely done by the.
We don't know. It is not your petition. Please understand. It's the petition filed by them, they are withdrawing it. How much time? Weeks time.
17,
Weeks time. No. We should not have done it. By filing a review petition, you are trying to tell it that we should not have done it. We will recall the order and hear your petition on merits. Dismissed on delay and access. You cannot file a petition right away and say that last year sports quota, I should have been given admission. I am playing chess, skates and all that. So, no, nothing wrong. Nothing wrong. We don't. No.
Let's see.
We will not permit reopening. You should have gone to Supreme. Why? What were you doing here? Nothing. We have said, Mister, we have declined to exercise the extraordinary jurisdiction. That's it. You say that it is erroneous before the Supreme Court. You tell the Supreme Court. Nothing. No error apparent on the face of the record. Nothing. No. We don't know. No. We have asked an order. It may be wrong. That we cannot travel outside the scope of review jurisdiction and do whatever you feel like. We can't do it. We are bound by law. It's not, there is no error apparent on the face of the record. The court has declined to exercise the extraordinary jurisdiction in the facts of the case. If according to you it's erroneous, please challenge it in appeal. And we don't know. No consideration. We can't, undo the things at this point of time. What were you doing? That's the judgment about this. You know it if you have read it. If you have read the judgment, you know what are the reasons. Fine. Third, this petition has been filed seeking review of the judgment dated 13th of December 2022, passed by the WP 23265/2022 after hearing learned counsel for the petitioner. In our considered opinion, the judgment neither suffers from any error apparent on the face of the any jurisdictional infirmity warranting interference of this court in exercise of review jurisdiction. In the result, the review petition fails and is hereby dismissed.
When to pass over this case?
Awaiting service of notice 1 and 2. So, what do you want? Asshole. Your friend is making a request for password. It's difficult to understand, right? No. Not so difficult, right? Awaiting service. What happens to R4? I mean,
Let's
okay. Yes. Mr. Vivek Subbareddy, senior counsel for the petitioner. Mr. Ramesh, the government advocate. Yes, write their name. Service of notice on respond number 4 is awaited. Learned senior Mr. So and so, learned counsel for the petitioner states that he shall take out and summons for service of notice on respond number 4. The aforesaid submission placed on record list on 5th of January 22. 23 or 22. Yes, 23. Yes. 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 What recalling the order? What discuss? Dismiss for want of prosecution. What happens when 2012 matter also you don't appear? 11 years. That's why nobody is interested. No, but please appear, I mean, otherwise we will impose heavy costs on you. If you don't appear, it will not only be dismissed, but I mean, before restoration, you will have to pay exemplary costs. It's 2012. Please appear. It's a sign. Order dated 15th November 2022, the recall WA 5732/2012 is restored to file. It is learned counsel for the appellant undertakes that he shall remain present before the court on the next date of the hearing. Let the appeal be listed for petition be listed for appeal be listed for hearing. IA before that you write IA 1 of 22 is allowed.
File application for the petition of service in way of paper application.
Hold on IA 1 of 20 an application. Let notice be published for Vijay. Bangalore. Bangalore edition for appearance of respondent number 4 on which date? 6 February. Accordingly, IA 1 of 22 is allowed.
22, that will be 100.
We should delay. Yes, what do you say? Delay and all. Allowed. It is IA 1 of 22, 2 of 22, 3 of 22. 1 of again 1, 2, and 3. Allowed. 3 of 19. Objection. So 1 and 2 of 19 we can allow, right? So you allow 1 of 21, 2 of 21, 3 of 21.
3 of 19 is to bring.
1 of 19, 2 of 19 allowed. Let the appeal be listed for consideration of IA 3 of 19. Next week.
Is to bring the alerts.
So he is opposing that. 3 of 19 you are opposing. Office of the. Oh, all right. That's allowed. 3 of 19 allowed. Don't write. 3 of 19 is also allowed. Let amended cost title be filed within a week, list thereafter. Yes. Yes. Yes, then say let steps be taken. Substitution of alarms of disease, respond number 5A.
23. Char Kumar,
What direction? The counsel for respondent praised for granted a week's time to enable him to file objections to IA 1 of 21.
number 24. The Revati Adinath Samaji, he will reply.
What direction, madam? What? All right. All right, yes. Mark represents this appeal arises from a order passed by learned single judge so and so. The controversy involved in this appeal is clearly covered by judgment dated. What is the judgment pattern date? Judgment dated so and so, passed in writ appeal number. So what has happened there? The appeal is disposed of on same terms and with similar that. This appeal therefore, for the reasons assigned in the judgment, the appeal is disposed of and with similar that.
Number 25. Char Kumar.
What withdrawal? Withdrawal. Huh? What withdrawal of the amount? He is making a statement. I mean, you are not aware, fine. There is no reason to disbelieve his version, right? Learned Counsel heard on IA 1 of 21, Learned Counsel for the applicant submits that the dispute between the parties has been amicably settled and the execution proceedings have been closed on the basis of compromise arrived at between the parties. He therefore submits that he be permitted to withdraw the amount deposited by him. It is directed that the appellant shall be permitted to withdraw the amount deposited by him, subject to verification. Accordingly, IA 1 of subject to his furnishing identity. Accordingly, IA 1 of 22. Appeal has been disposed of, right? He says. Appeal has already been disposed. This what early hearing?
May I please?
I appeal for the respondents, sir.
I appear
What
for the. Court may kindly recollect this matter was heard at least half a dozen times, but it came to be adjourned thereafter. After a direction was issued to the respondents to
So
produce.
this IAP have already passed in January. Right? See, registry is so prompt. We said IAB listed for consideration in January. It comes upon opening date, 2nd January. So you can't doubt the efficiency of the registry. Right? So which
But,
date? What is it about?
The matter relates to recruitment to the post of registrar in the respondent institute.
Assistant registrar.
So 3rd week of this thing, 17th January.
Please.
18th January, Mr.
Please.
Please.
18th January is convenient for both of you, right?
Yes, sir. Yes.
Heard on IA. Heard on IA 2 of 2022, an application in early hearing for the taking into account the fact that it is pending before this court since 2019, as well as the nature of controversy involved in the appeal, the same is allowed, IA is allowed. Let the appeal be listed for final hearing on 18th January 23.
18. Please.
18th.
Please.
Yes. What were you doing 601 days? Not aware. Ex parte. Heard on IA 1 of 2019 for the reasons assigned in the application duly supported by an affidavit, and as well as taking into account the fact that an ex parte decree has been challenged in this appeal, delay of 610 days in filing the appeal is condoned. In the result, IA 1 of 2019 is allowed. Appeal is admitted for hearing. Office is directed to secure the record of the family. 28. What recalling, madam? What dismissed? Dismissed. Signed. Supported by an act dated 6/2/21 is recalled MFA 9071 part. IA is allowed. 29. This what direction? What is direction?
Only stay, there is no. There is only stay of the.
There is no direction. Stay of the judgment, right?
Case is that the that he has made.
Married. Consider it at the time of hearing. IA 1 of 20 shall be considered at the time of hearing of the appeal.
Number 30.
My lord, in this case, my lord, I have sought for recall of the dismissal order dated 14/10/22, my lord,
Fair enough.
for non-compliance of office objection.
What to do, Mr. This appeal is of which year? 21.
My lord, 21, my lord, there was lot of objections, my lord. There was a lapse on my part. I don't say. Kindly give me 2 weeks time, my lord, by recalling the order and complaint.
That is signed in the IA, order dated 14/10/2022 the record. In the result, IA 1 of 22 is allowed. Let office objections be complied with within 2 weeks.
Obliged.
What? Peremptory. Same order. Weeks. Wait 2 weeks, right? Third on Wednesday. Third on IA number. What is which IA? 2 of. What you are looking at your mobile? You don't have.
Here to for recalling. Here to for recalling.
Dispensation, right? You have filed some IA or not? Which IA?
IA 1 of 22.
1 of 20. Dispensation. And in the application, please support. Requirement of filing the translated version of the documents is dispensed with. Result IA.
32. This is Dina TK.
Yes, madam. Okay. Lakshmi Narayan Learned, government advocate, correspondence number 3 and 7. Praise fund is granted. Weeks further time. You also want to file, Mr. Shanti? 2 weeks. Praise fund is granted 2 weeks further time to enable you to file order. Examine, we don't know. He seems to suggest that rules have been further amended. Yes.
33. Can't hear it.
Normally, in the land revenue proceedings cycle will not be gone into. For the first time, in the repetition, decided about my title, so I was in effect, a declaratory decree has been granted saying not very existing.
We list it for admission. Day after, let Jay Kumar Patil, counsel for the applicant, let the appeal be listed for orders on admission. 4th of January 20.
Government advocate.
Right. Whatever. Also, we have. You have filed the objection. This is right. Repeatedly, it is coming up. IA 1 of 22 is allowed, right? Dispensation, item 34, allowed. Petition is admitted for hearing. Learned counsel for respondents may file objections within 3 weeks if so. Acha, so learned counsel for respondent number 2 may file objections if so advised within 3 weeks. You know the result, right? What will happen? We cannot. Whatever, let them file objections. It will come up after 3 weeks. What's your name? This is directed to reflect. What's your name? As counsel for the petition.
Submission number 35.
And appeal is admitted for hearing. Record is there. Huh? Office is directed to secure the records.
36. In Murugate with Therapy, government educate.
First time. Learned counsel for the. Also, previous writ petition on same cause of action was pending, right? That's. What is your case, Mr.? What is just, why are you opening the file? Just tell us, what is the point? Respondent number 1, A and C. So what is the point, right? It says either you allot them the similar land or pay compensation under 2013 Act. So is it your case that you have already paid compensation? So you have paid.
They say it is complied.
They say that it has been complied with, right? Learned counsel for respondent submits that the directions contained in the order dated 7/10/2017 passed by learned single judge have been complied with. In view of aforesaid submission, learned counsel for the appellant prays for short accommodation to enable him to seek instructions. In the meanwhile, learned counsel for the appellant is also at liberty to make an application seeking substitution of LRs of disease respondent number 1A and C. 1A and C. List after 2 weeks. What report is awaited? Appeal is admitted for hearing. Record.
Number 38. Please read that. Article 133.
What? You want to file objections or not? What is this? You have been seeking time and one fine day you say that we don't have copy.
Denied the benefit of granted. The said while the judge is not in their case. How the institution has Institution is not interested to proceed. Extend only to the institution. How the employee can maintain it.
Ask it.
Now the institution has withdrawn the appeal. It's correct. The institution does not want to prosecute. How the employees can maintain it? The burden is on the institution because the government has denied the benefits to the institution. They had preferred the appeal along with you and they have withdrawn. Where is the question of impleading them now? This order is also not their case. In some other case.
So what is the locus, Mr.? No, your locus.
But even the single judge order is not passed in your case. It is passed in some other's case. And there is an endorsement issued to the institution. And the endorsement is not questioned by you. That binds the institution. Unless that endorsement is questioned by which has been issued by the state government, how you can maintain this? That endorsement is there. You have not questioned it. And you cannot question it in a writ appeal. You have to file a writ petition separately. That has been decided not in your case. In your case, they have issued an endorsement based on the judgment passed by in some other case. If you are bound by if you are agreed by the endorsement, you are required to question the endorsement.
Hey, what is this? Please answer this. What if each time nothing will? You can't improve the. You can't improve the facts within a week. The query will remain the same. So answer it. What is there? We will grant you the liberty to challenge the endorsement. You are prosecuting your remedy before. Then what? No difficulty. That doesn't give you. My Lord has asked you 2 questions. Please answer that.
That cannot be done. You have to question the endorsement. Otherwise, that. Even otherwise, this appeal cannot be maintained by you because the institution is not before the court. Yeah. Any person who is agreed is by the institution, not you. No, that is for the institution. Institution is handled the burden. They are not. It is if the burden is on the institution.
It's paid by the state. It goes into the account of the management is saying
Now the burden of payment is. And the appellant has filed a memo that the appellant number 2 and 3 have been already dismissed from service. That is the memo filed by them that you have been dismissed. You are no more there, sir.
This is the. Please answer the query. What is there after this?
Are you still in service? Are you still in service? You file an affidavit that you are in service.
Counsel for the appellant praise fund is granted a week's time to enable him to file an affidavit that the appellants are still continuing in service. In addition, learned counsel for the appellant shall also apprise this court as to how this writ appeal can be entertained at the instance of the employees when the institution had filed a similar writ appeal and the same has already been withdrawn. List on 9th of January.
Institution and other file. Institution has withdrawn.
Acha, and the delete that the second this thing. When a query was put to what delete, when a query was put to learned counsel for the appellant that delete. The appellant as well as the employees. No, the employees as well as the institution had filed this intra-court appeal. However, institution has withdrawn
Withdrawn
the appeal. Therefore, when a query was put to learned counsel for the appellant as to how an appeal would be maintainable at the instance of the employees, learned counsel for the appellant prays for short accommodation to enable him to address this court on the aforesaid point. List on 9th January 23.
39, Ramat Korea, A. Prasanna Shetty.
Admittance of hearing record. Record is has come.
Yes.
Right. So then only admitted for you.
40, government advocate, please Suyog Herade.
Respond number 2. All right, so allow. So we'll allow the application. 40. All the applications are allowed. Let amended cost ID be filed within 1 week. 1, 2, and 3 of 20. Yes.
41, Timothy Amar, Nata, government advocate.
Dispense with third on IA. One of one requirement of filing. Yes. Why? Yeah.
They are served.
So
Respondents are served.
respondents are served. Nobody is appealing.
Karnataka,
Appeal is admitted for hearing. Learned counsel for the counsel for the appellant submits that the assistant commissioner as well as deputy commissioner exercising powers under PTCL Act ought to have appreciated that there was a delay of 11 years in filing an application seeking resumption of the land. Appeal is lying below. Appeal is admitted for hearing. In order, if any, shall continue.
42, the Venkatesh Sarvati, government advocate, the SD Mukananta.
Let him saying something is for you are saying that appeal should be allowed. Huh? You're not permitting him to argue. He should take this.
Appeal, there is no question of B group, it's a writ appeal.
He'll admit it. Appeal is admitted for hearing. Interim order granted on earlier.
Delay has to be done. Delay has to be done.
Acha, delay. Delay of 84 third on IA 1 of 21. Delay of 84 days control IA is allowed. Then appeal is admitted. Dispensation is also 4 of 21 dispensation allowed. And appeal is admitted for hearing. 5 also 4 and 5 dispensation. Appeal is admitted for hearing. interim order shall continue accordingly. IA. Two of, how many, why two application? Accordingly, IA 2 of 21 and 3 of 21 are allowed. Interim order shall continue during the pendency of the appeal. Yes.
43, ಶ್ರೀಮತಿ ಸುಮನಾ ಬಾಳಿಗ, ಏನ್ ನಾಗರಿಕ
What happened? Oh. Yes. Where is the order of termination? It was page 84, 83. 85. Yes. It's page 84, madam, translated. Yeah, 28 to 2015, right? Order is dated 28 to
23/3/2015,
23.
page 91. Right in line. Please.
Translated version is there at 92. Translated copy is there at 92. You can read. Okay. It should be to start with.
And the application is that you went against the government.
So is it not stigmatic? Is it not stigmatic? Why? You say that he has two things you have said against it, right? That he has failed to achieve the target and secondly made some statement against government. So should it not be preceded by an inquiry? Simple.
The principle is that once there is an
Can't dispute this proposition, right? That if a order is stigmatic, it has to be preceded by an inquiry. Whether or not it is stigmatic, it has to be decided in the facts of that case. Then you have made, you could have said that your services are dispensed with by giving you a month's notice or something like that. But you have chosen to say that he has made a statement against government. Number two, he has failed to achieve the target. Then would it not this thing cast a stigma on him? To what?
Where is the reply? Mr. M is not the reply.
Next at 3 lots, 3 of 80. Another one is completed the table.
Not admitted of yes, in a representation on behalf of the state. Other employees to give us salary, there is no implementing is the government.
So that made a statement. Given the permission to conduct the inquiry, here what are the by the payment of
But there is no admission, madam, as such. No admission.
Page 8.
Page 88, 88. 88.
being vice president of nodal officer to the behalf of it was to release of management of 65 2016 not given the individual statement either against statement if there is any inconvenience caused to the government, I may be asked to say that I will not give that statement here. In Kannada, it was
Yes, given to hold an inquiry.
By now, you should have held an inquiry and done away with the services instead of contesting this litigation.
yeah.
Yes, that's it. Ma'am. Anything else?
Yeah, make the statement against the government.
Yes.
Because during the case, admittedly, it is corresponding and during the relation of after the
It won't apply. Work no pay will not apply where you prevent a person. Yes. Yes. All right. Thank you.
realization of the concept of only
Thank you.
44, the NC Basura, the HR, HR,
Three weeks time. Permit counsel for the applicant place fund is granted 3 weeks time. Enable him to place on record the medical report of the applicant. Wait. Next, yes, 43. This inter-court appeal has been filed against an order dated 26 November 2020 passed by learning single judge by which writ petition preferred the respondent allowed and respondent has been allowed and the order of and the order dated 23/2015 by the respondent services has been displaced, has been set aside. Also been held entitled to monetary benefit. That's giving rise to filing of appeal briefly stated that on contract basis Taluka Nodal Officer by an order dated 23/3/2015, the services of the respondent were displaced from the Taluk Nodal Officer. Full stop. The respondent challenged the aforesaid order in a writ petition inter alia on the ground that the order is stigmatic in nature and is not preceded by an inquiry. Paragraph. Learned single judge by an order dated 26 November 2020 quashed the aforesaid order and has inter alia held that principle of no work, no pay shall not apply to the facts of the case. The respondent has been held entitled to monetary benefits. Full stop. In the aforesaid factual background, this appeal has been filed. Paragraph. Learned counsel for the applicant submitted that the services of the respondent have been terminated in accordance with the terms and conditions of the order of appointment, and therefore no inquiry was required to be held. It is further submitted that alternatively it is submitted that the respondent had admitted the allegations made against him and therefore admitted facts. The impugned order dispensing with the services of the respondent has been passed. On the other hand, learned counsel for respondent has supported the order passed by the learned single judge. Paragraph. We have considered the rival submissions made on both sides and have the record. Stop. It is full stop. It is the legal position is well settled that in case an order is stigmatic in nature, the same has to be stated by an inquiry. Full stop. Eastern case, the from the impugned order dated 31/1/2015, 23/3/2015, 23/3/2015. It is evident that that it is stigmatic in nature in as much as it states that the petitioner had that the respondent had made a statement against the government and had failed to achieve the target fixed for him as Taluk Nodal Officer. Full stop. Therefore, the order ought to have been preceded by an inquiry. Full stop. The learned single judge, therefore, has rightly quashed the impugned order and has reserved the liberty to the appellants herein to conduct an inquiry and to pass a fresh order. Paragraph. We do not find any ground to differ with the view taken by the learned single judge in the result appeal fails and is hereby dismissed.
Right, yes, again.
On amendment, the cost type. Yeah, here what was the cost? P2020. In view of order 2022, it is not necessary to amend the cost typing. The office objection is therefore ignored. Yes. The office is directed to delete the name of Mr. Chekmani Patil, who appears for this thing.
No, it's not Abhishek Mali Patil, my lords. I appear for the respondents.
Your application has been already disposed of.
Yes, my lords, disposed of, my lords.
Therefore, your name has to be deleted from the cost list.
Please, my lords.
Very good, right? Appear in the comforts of your office and get to know from the judge why. Ask a question to the judge. He will tell you, what is this? What capacity you are appearing in this case? All right. We don't want to begin the new year with you. Fine. So, what is it, Mr.? Who appears for them? Respond number 1. None for respondent number 1. Appeal is admitted for hearing.
Party Sri Y.K. Narayan Sharma, K. Shyam Prasad, K. Anandram, Government Advocate.
Liberty to issue sensible. In 1972 and 78. Section B.
Oh, you have challenged the order in your favor. So learned single judge should have dismissed. Learned single judge should have dismissed for petition.
Learned single judge ought to have said. Already and report is given saying that there is no. I want to re-educate the matter. That was also produced. And in view of that, there is no question further inquiry.
Not further inquiry. We will grant them the liberty to issue a notice if so advised in accordance with law. That's it. If it is law permits issuance of a fresh notice, they will do so. Liberty.
I'm finding it, or finding the lordship is not required in the present case. That portion of the order only I am challenging. The lordship can see a few facts I would, because it's already concluded. That's why 73-78 annexure B and ERB grant made, and under 56 of the Act, it could be challenged or revision to be made only within 3 years. And several decisions are saying that even if time is not added, but either. Now 72-78 grants are challenged by other persons saying that there is some misrepresentation. Then my lord, one of the point number 5.
So have they issued the notice? Have they issued the notice to you?
That notice is challenged and it is said.
No.
Notice was issued and it was concluded. Inquiry was
Fresh
concluded.
after the order passed by the learned single judge,
Yes,
that they
they have now issued a notice.
fresh notice.
Fresh notice they have issued.
Well,
And they are not proceeding further. There is a situation. And now they.
when they issued notice to you, when?
It is,
Whatever has happened earlier. 24/5.
An application was given again before the.
Yes, I should. Date of receipt. When did you receive the copy of the order? When did you receive the? You know, who has issued notice, Mr. Ah, yeah. 24 May. Ah, yes.
March, sir.
Yes.
I secured a copy of the notice, fresh notice. It is dated 28/4/21. And,
You can raise all your contentions to that notice, right? That it is barred and all that.
that has been done here. That has been done in the previous proceedings between the same party, and one of the applicants was father of this refundable fine, contesting refund. That was concluded, and the commission has passed the fine. Consultant has passed a report saying that all everything is in order, and after so many years, 30 years, I can't do it, or it is not necessary, then I have to do it. Excuse me. In that view of the matter, that matter has been concluded. And again, they are giving a fresh petition, saying that make a further effort. On that basis, they have issued the case notice, that is challenging the repetition. Then I said, a repetition, the whole thing is use of process of law, and the particulars are also not given now. Anyway, the matter has been concluded earlier, anyway, all that don't precipitate it may be closed. However, the learned judge, sorry, honorable judge has set aside notice and said that fresh notice may be given. That fresh notice is not contemplated, not required, because there is a complaint regarding grant of 72/78, which has been inquired into subsequently between the same party and concluded. That is why
When it was inquired in. When it was inquired in.
that is what we not did. It was 94, election P. Page maybe 123.
Page 123.
When the present compilation 3182. And actually, yes, my lord. 31,894. Page for the other complaint, page 135, it is rejected. Then doctor inquiry.
Yes, Mr. Has it been inquired into? Yes, madam. Hey, what record? I mean, you see on it, that page 124. $13,396. Twice it has been inquired into. No, not direction, liberty was given. So supposing if that's the grievance, right? He says that twice the complaints made against the appellant have been inquired into. How long? The grant was in the year 1972 and 78. And what about limitation? How within how much year? How much time you can initiate?
One more. Page 175. Proceedings are drawn by accountancy. That also I produced at 1980.
We have got it right. Yes.
All these things are completed 3 times. And it is a refuse of process. That is why I am before what it says no further.
What is the limitation? Limitation for it. Yes, madam.
Now that portion is not challenging, but they have accepted that portion. Now, from 5 to 50, is not the.
Whatever ground, once it is set aside, what is the effect? Whatever ground is set aside, what is the effect? The learned single judge has not said that the same notice should continue and they should file. Then a fresh notice, right? So this complaint has already complaints have been made against the grant and they have been inquired into 13th of January 94, 13th of March 96. These are the two dates. And what is the limitation for initiation of 56.3?
There should be in the endorsement saying that there are original records available and therefore not we are satisfied with the grant. Now all subsequent endorsements not stem out of these two endorsements. I have submitted representations, 14 representations to the authorities to provide a copy of the original records. They have given 14 endorsements saying original records are not available. So you should kindly see your annex A. Annex A at page 240. Here are the one are the endorsement dates right from 1997. They are saying original records are not available in the office. When I ask for an endorsement, when I give a complaint against that the fraudulent grant, they say ask for the original records to be proper. Then the law, 33 acres has been granted, and one of whom is the NRA. These are government lands, which have been granted to not one family of the 33 acres of land. So therefore, Lord, I find a petition before the Tahsildar and inquire into the very we not status in the year 2014. Earlier, we not with some other topic who are running for those who are side under the various cities. Rather than after that, I find in 2013, 14, when these endorsements would be saying records are not available, so inquire has to records are available. You not there are not being dissatisfied when the customer inquiry was going on. So the inquiry was of the year 2014. Because we not satisfied about the assistant commissioner by way of connection A. If connection A has page 240 14 endorsements there. All these endorsements have produced as annexures in the connected research and those documents were not produced. All representations were heard together by years of state orders and not
The government land you are making, you are a person who has been making complaints, right?
not only me,
You want these lands. You want allotment of these lands. Did you make an application?
No, I was not this responding from other also rival cases. So because some of these lands were concerned, where they had tried rival land. Those applications were decided in the countries. There are four representations to find, not only by the but also other villages, saying that these lands are popular lands. Therefore, I have sought for original records. 1997, they have been issuing endorsements to the state original funding not available. Even now, my management can produce the original file. My information does not exist. There is no original file with regard to this grant. That is why I will start for an inquiry. In several survey numbers, various of the family, one of whom your teacher,
How you understand who is NRI? Yes.
I did not
No. Yes.
Yes. You have seen that when I apply for the original record and copies of grant, the original records are not available. original records are not available. From the 14 endorsements that they have. Right from 97 to 2014. When I complained about that, they say we have seen the records, grant is proper. They say give a copy of the grant order and other records, the records are not available. Putting the disconnect connection. If the copy is not filed, there will not time for.
But those orders also have attained finality, right? Deciding the complaints on an earlier occasion. Whatever he said, he told us there were 2 inquiries, right?
Very.
So, madam, you produce the record. Let us.
What he say, what he saying that reason given 246 page. Final endorsement issued by the President and ultimately husband and also brought. Please see the reasons given there. But I'm not. It is not available record and etc. This is not the question now. Because it's of 1972 and all. Now the endorsement dated. 246. English.
Is it? So what is it? What does it say?
There is an endorsement include on a complaint based on the further also brought the proceedings. Please see the application given by very same person, you know, the person, you the land informs that the father has applied, that is rejected and you get penalty. I have produced the connection. Now this document you are to he referred to all these things and says that after this 30 years or beyond this, that we can't go into all these things. And earlier itself, in 96, the earlier order, you have finalized and made it closed it. That is the reason given by in the endorsement details. And now there is a question of asking in another proceeding, production of 72 grand order, you will not know this revenue side. 70 to 1972 records where they will get, I don't know whether it is available or not. I am not a party to that now, that it's a different reputation. Whatever it is it necessary? Under these circumstances, is what it may be, it is, that's why I'm saying, in the amount of already concluded trial, and now it is an accused, again asking you to go and face the same inquiry before the same revenue officer. All these things will not be said to put an end to. You are accused by order, he can't be tried more than once. He said, we are harassing me, we are not able to develop the land, they are going on giving complaints. And the authorities are not permitting us to develop investment and development. That kind of situation is here. And 70 to 78, how this it could be now they are asking for in the other equations on the records of 72. This may not be my submission is this does not call for. I have produced all these records. These records they are not challenged, they are available. That is the records of the government itself. They indicate that there is no further inquiry called for. It has been concluded twice. It is not that government will not produce the documents. Under these circumstances, we are keeping it pending, and again that inquiry notice has come, and on his complaint saying that there is an order for fresh inquiry, issue notice. This is the kind of harassment. This is not abuse. And I am only appealing to your lordship. This abuse has to stop. And one more thing is, my lord, your lordship see the writ appeal. One of the persons who has complained filed an affidavit. It is available on record, saying that at the instance of somebody else, I have filed that complaint. I don't want to pursue that. This is the situation. It's not a case where it has to stop. Some end. 74, 78 transactions now inquiring into and keeping it pending and harassing this. That effective with proper manner is question. And this father applied under 7 land function. That has been dismissed. It's another proceeding. as we say, we say, others also apply for grant under land, that is also here. Pay 80 divided 80, pay 80 is also get, I told you that pay is not. And the very same person's son now goes on giving. And one more person is set up, and that person comes and files an appeal saying that I am not interested in pursuing. This kind of thing, I think, I request you got to.
You should.
Original file is produced.
No. All right, madam, you produce the original record. Learned additional government advocate praise fund is granted. How much time? 2 weeks time to enable her to produce the record pertaining to grant in question. Water shall continue. After 2 weeks, it shall come out. 23rd January. 23rd January. List on 23rd January.
Number 47. Hare Krishna is full up. Please look over here.
What 391 days? What is it? Delay. Objection. Section 14 Limitation Act, they are entitled to benefit. We condone the delay, hear you on admission. Heard on IA 1 of 21. After hearing learned counsel for the parties and for the reasons assigned in the aforesaid IA, in our considered opinion, sufficient cause for condonation delay of 391 days in filing the appeal is made out. Accordingly, delay in filing the appeal is condoned. In the result, EA 1 of 21 is allowed. Let the appeal be listed for orders on admission as well as for consideration of IA 2 of 21 in the next week.
Number 48.
No? 9, 10, whatever. 9. Learned counsel correspondent number 1 to 3. Raised for adjournment on the ground that arguing counsel is not available. This on 9th of January 20.
I did not have the entire. Only one document which I was not able to get. Other documents are taken from various departments. 64/2018, they say there is a recommendation brought from the government to the government. They will DC not. That may have some relevance if they have it.
All right, let's see. My interim order granted on year occasion.
49. Abhinav Ramanand. Date transaction. Certificate.
How can there be a shortage when he is appearing? Huh? Huh? What was challenged in the writ petition? Was auction sale. That was 6th of April 2015. What happened? The auction sale took place or did? Then
That will doesn't seem to be direct back to them. Overlooking the fact that there is a degree against them, 4.5 crores is liability to be paid, and that we have to pay.
What was the amount? 1.4?
1.4 crores. Deposited. In the meanwhile, it's a dispute under the cooperative society that against the appellate bank say that you have adjusted various views against us. Those views you could not have adjusted as against us, even though they are sister companies.
So what is your challenge to the improved order?
They could not. But there is a duty that is existing.
It's at page 21.
Please have a look at law.
Hey, just
Page 74.
so Mr. Whatever order. When you there was an auction notice, right? You got it state subject to a condition that 10% of the amount should be deposited by you. You deposited that amount before this court and got the auction notice postponed, right? And thereafter, no. No, but you had, Mr. That is what is the point, right? I mean, you get an interim order and thereafter get the benefit and then withdraw the petition and go away with it. Who has adjudicated? Who has adjudicated this issue that you have paid the amount in excess? There is no adjudication by learning single. The amount you have got their auction notice state, right? You have taken advantage of the interim order and taken away the money also, and later on saying that this amount could not have been given to you. It should be kept in an interest bearing account subject to adjudication of the dispute between you and the water. So where will you deposit the amount? Not received. Good. Otherwise, things. Interest bearing account subject to outcome of. Fair, right? That's how it should be. Yes. He was right for a change. There is a small, what did you say? Small involved. We thought that short. Yes. This intra-court appeal has been filed against an order dated 17/9/2000. Single judge in WP number 19573 bar 2015, by which the single judge has permitted the respondent to withdraw a sum of rupees 1.4 crores deposited by the respondent in compliance of the interim order of stay on 5/5/2015 paragraph. Learned counsel for the parties jointly submit that the dispute between the parties with regard to the recovery of the amount in question is pending adjudication. Before. So, already, what learned counsel for the party jointly submit that the dispute, dispute between the parties is pending adjudication. Adjudication in appeal number 133/2016 before the Karnataka Appellate Tribunal. Full stop. It is further submitted that the amount which has been deposited by the respondent in compliance of the interim order be made subject to decision of the aforesaid appeal. Right, paragraph. In view of aforesaid submissions and in the facts of the case, it is directed that the amount deposited by the respondent in compliance of the interim order passed on 5/5/2015 shall be kept in an interest-bearing account by the respondent. Shall be kept in an interest-bearing account by the appellant, and the same shall be subject to outcome of appeal number 133/2016, which is pending before the Karnataka Appellate Tribunal between the parties. Line below, to the aforesaid extent, the order passed by the learned single judge is modified. Accordingly, appeal is disposed. We don't know. You have said that dispute is between pending before the KAT. We have made it subject. You can make that submission before the KAT. All right, needless to state, then line below, aforesaid extent is modified. Needless to state that it will be open for the parties to raise all contentions before in an appeal which is pending before the Karnataka. Line below, accordingly, the appeal is this. All right. Where you have said this, you say respondent number 1.
50 round to look at the
Why?
Mr. Subramania, additional education, Mr. Subramania will be arguing this matter, madam. He's on his leg in another court hall today, madam.
Speaks. Learned counsel for respondent praise fund is granted 2 weeks time to enable him to make objections to the pending interlocutory application. All right. Issue notice list for issue notice of IA 1 of 21 and 2 of 22 list for analogous hearing along with WA number 325/2020. We don't know. In addition, shall be in addition, learned counsel for the appellant shall be at liberty to serve the counsels who represent the respondents in connected appeal. Then say list for analogous hearing along with WA number 325/2020.
52, Anusha,
So IA one of
33, government education, CBF,
third, third on IA number 1 of 2022, an application seeking condonation delay of 65 days in filing the appeal after hearing learned counsel for the parties and for the reasons assigned in the aforesaid interlocutory application, the same is allowed. Delay of 65 days in filing the appeal is condoned. Let's say same is allowed. Yeah, same is allowed. Let the appeal be listed for orders on admission next week. Next week. List after 2 weeks on the next date of hearing. Additional advocate shall produce the record.
government education.
54, not, I am appearing for the appellant.
Yes.
This is a matter not relates to grant of occupancy right in land bearing survey number 47. The appeal is by the
Issue notice
respondents.
of IA. Issue notice of IA 2 of 22 as well as 1 of 22 to respondents.
May I make one request? They have already initiated contempt proceedings.
What can be done? There is a delay. Serve them. Take out hand summons if you want.
Would your lordship have it not on the 10th? I will serve them by hand and.
In addition, learned counsel for the applicant shall be at liberty to take out hand summons for service of notice on respondents list on 10th of January 2023. Yes.
55, government education.
Yes, madam. Nothing.
Review petition 758 and notice has been ordered in 758 of 2022.
So then you withdraw. Additional government advocate fairly submits that against order dated 15/4/2019 passed by the learned single judge. Review petition in the RP number 758/2022 has been filed in which notice has been issued. In view of aforesaid subsequent development, learned count additional government advocate seeks leave of this court for the appeal with the liberty to revive the same. So we don't know. It will be a fresh thing, no, if in case. With the liberty to challenge the order depending on the outcome of RP 758/2022, line below accordingly, the review petition dismissed as withdrawn with liberty as a portion. Writ appeal. Writ appeal is dismissed as withdrawn with liberty as a portion. Pending ideas are dismissed.
53, yes, Satyananda, Gurraja. Satyananda.
Also, you have busy somewhere else. Huh? What do you want? Some other none, none for the appellant. The learned senior counsel for respondent awaiting appearance of learned counsel for the appellant. Hearing is referred list after one.
Number 57, the Vice Rajendra Prasad Shetty.
Yeah.
Government educate.
On the basis of the registered training of 2006. Thereafter, the respondent not as private to declare
Correct. In your appeal, you is not party.
Property was prior to sale date manner. Question was please. If the petitioner, the appellant and the person are the system. The father.
Mr. The order has been passed without hearing him. Can you possibly defend such an order? You are arguing on merits. Has he been heard before passing the improved order?
The second appeal which you have filed, was he a party?
Then it has to go back.
Send it back.
That's all. You will remand. Huh? But where have you argued that it cannot maintainable or it is still pending? No, raise an objection, file an application. This thing that read petition is not maintainable, will request learned signal to decide that. Why to interfere in an interim? File an application, right? Consider re-delivery of possession. Shall consider. No, you file this thing, file an application. We will say so. That is your contention. You file an application, will request the learned single judge to decide this issue. Right? Nothing. Nobody moves a contempt. He's saying no. He's saying no. He's saying no. Yes. So you are not filing a contempt, right? No. Are you filing a? See, we wanted you to make a statement aloud so that Mr. Deshpande can hear. That's it. Yes, right. In this intra-court appeal, the appellant has assailed the validity of an interim order dated 21/11/2022, passed by learned single judge, by which writ petition preferred by the appellant challenging the what? Sale notice dated 15/10/2022 issued by the appellant has been entertained and an interim order has been granted. Paragraph. Learned counsel for the appellant. Just learned notices dated sale notice 15/10/22 and 8/11/20. Right. Paragraph. Learned counsel for the appellant has raised. So what is it? So there's no citation, right? Where from are you getting like internet free this thing without citation? Huh? See, what appeal number? This is a reported judgment. 2000, not reported. 12th January 22. Learned senior counsel for the appellant while placing reliance on decisions of Supreme Court in so and so. Right? These are the three judgments. The writ petition itself is not meant to us that even though such a contention was raised on behalf of the appellant, yet the same was not considered. Paragraph. In view of aforesaid submission, we permit the appellant to make an application regarding the maintainability of the writ petition before the learned single judge. Needless to state that in case such an full stop, we request the learned single judge to deal with such an application, to deal with the application, raising the issue of maintainability of the petition if the same is filed expeditiously. Stop. The appeal is with the aforesaid liberty, the appeal is disposed of. They are saying so, and we are more than convinced, right? They appear to be gentlemen, both of them. Right? Gentlemen in the sense that you will keep your word. That's all. We are not sitting here to give you any this. Gentlemen, he said that you will keep the word given to us. That's it. And will not put Mr. Deshpande in unnecessary trouble, right? They are saying no.
And MC Basavarajan?
Yes. Furnished a fake transfer certificate. What to, whenever fraud is detected. So in what ground? I mean, you should be, what is your submission? You should be permitted to furnish a fake certificate. And nobody, employer cannot take, no. Whenever fraud is detected. What is the law? Whenever fraud is detected, right? If you play a fraud and then you say, no, you cannot take action. Yes. But we are happy that you have not filed a petition to give you light duties, right? You have come up with something new in a new year. Yes. What to do? I mean, you have great fraud, Mr. And this thing, Supreme Court has, it has learned signatures relied on a decision of the Supreme Court. R. Vishwanath Pillai. Nothing. Anything else? No terminal benefits. If it would not have been a case of fraud, then we would have considered. Fraud, playing fraud. We cannot put a premium on fraud by allowing your rate petition.
HSDL,
No. Relied on a full bench.
That's a case, not the granting for permit. Grantee sold it in 1996. Purchase of garage in 1990, sort of conversion. Price from what time we can admit the granting seeks to divert it for various purposes. Then now it ceases to have. In this case, I have not sought convert. This is my purchase or convert. As opposed to organize sort of it ceases to have protection PPCL. That person.
And what about the delay?
Yes, concern. Exactly. I put that as because an above is how we grant. Another is page 16 above that the original grantee was based on
We thought that there is no bonded labor system after landmark decision of the Supreme Court. In Karnataka, bonded labor.
extremely there is a government, but I asked very simple. Which is why my explanation is that 6 or 7 years, because otherwise I may have to take tomorrow to it. So 6 or 7 years in the middle, because working in those conditions in the quarry, we did not agitate the legal then next year is
Notice on IA1 of 22 and 2 of 24, IA1 of 22 and 3 of 2020.
problems because we do not have
And 2 of 22 also, right? 1, 2 and 2 of 22.
but 61, government educate.
We have entertained, right? There, third on IA1 of 2022. The reasons assigned in the application, requirement of filing the translated copies of annexures A to C, F and G is dispensed with. In the result, IA1 of 22 is allowed. Issue notice on IA1 of 22 as well as 3 of 22. Yes, list for analogous hearing along with WA number. 24/2015.
First over matter. Bill number 80. Company budget.
Yes.
Before clearing the matter. 18.
So you are appearing for 1 and 2. Filing of acknowledgement. You are on admission. List it for admission. We will list it for admission next week. Let the appeal be listed for orders on admission in the next week. Before that, you write, Mr. So-and-so learned counsel has entered appearance on behalf of his number 1 and 2. Office is directed to reflect his name as counsel for respondent 1 and 2. Then say, let the appeal be listed for orders on admission in the next week. Okay, Mr. Objection? Yes. Yes, Mr. Object. What copy, Mr. Last date also you sought time to file objection. And today you said you supply copy. Learned counsel for the petitioner once again learned counsel for the petitioner undertakes to supply copy of the petition to learned government advocate during the course of the day. Line below. How much time? Learned government advocate placement is granted 2 weeks time. Objection. Then in the beginning you write, let a copy of undertakes to supply copy of petition to learned government advocate as well as in continuation of, as well as to Mr. Om Kumar learned counsel who appears for the fee regulatory committee, namely respondent number 2. Right. The learned government advocate press for 2 weeks time. Yes.
Final reading number 63.
Appear for the appellate.
Respondents council.
Oh, yes.
Well, yesterday my learned friend called me. Said he wanted some copies of some papers.
Oh,
which
it's
doesn't
a
have.
case where you are telling that if you make copies and gives it to him entire.
What happened? I could not contact the council on record. If my learned friend can go send his clerk to the council on record is very nearby his office, they will give the copies, my lord, by he can Xerox it, my lord. I am not able to do it myself.
Yes, Mr. Rao.
I thought, my lord, he said he will give me a paper book, the entire inquiry proceedings. My lord, I will, now since my learned friend says I have to take, I will do it. I have no other choice. I will do it.
Yes. So,
He can only send his clerk to Mr.
No. I said I means somebody I will have to send on my behalf.
That's all.
Next week, Mr. Rao.
As your lordship pleases. My lord, I am myself anxious, my lord, for an early decision.
So you tell us when you will.
Yes, my lord.
We don't want to adjourn it further.
No, your lordship, my lord, with the
whatever material, if I am not able to get, whatever material is before the court, I think I will request your lordship to
Lord,
give.
if he wants only the inquiry proceedings, I'll ask my advocate, Lord, on record, to kindly make a copy and give it to him, Lord.
So
If it is
when
only
do
the
you
inquiry
want,
proceedings.
you tell us when
I'll
you
ask him to do it, no problem.
date, Mr. Next date. Date.
Date, my Lord, can be held on 10th or 11th. Lord.
Mr. Rao,
11th, your lordship may have it.
Direct Council both parties jointly pray for adjournment. List on 11th of January 22.
11th, huh?
January. Yes.
Yes.
Yes. Huh? So we shall hear it. No, but don't finish before he comes. Lighter wind. Yes. You tell us what is the 25 years? Or let him come. We don't know. Give that file to me. I'll dictate. Yes, yes. Ah, yes. Yes. You have done your job. Copy has been filed against an order dated 23rd of April 2021. Asked by the single judge, by which writ petition preferred by Karnataka State Road Transport Corporation, herein after referred to as the corporation, has been allowed, and the order dated and the award dated 27/1/2016 passed by the labor court has been set aside. Set aside, the learned single judge has restored the penalty imposed on the appellant. The learned single judge has restored the order of dismissal dated 25/3/2014. Paragraph. Facts giving rise to filing of this appeal. Briefly stated are that the appellant was appointed as a trainee driver on 7/12/1987 in the corporation. Full stop. On 18/7/2009, a complaint was received by the security officer of the corporation on the ground that at the time of selection, the appellant had furnished fake documents. Full stop. The appellant, the corporation thereupon conducted a domestic inquiry, and article of charges were framed on 12/12/2009. Full stop. The respondent furnished the reply to the articles of charges. Paragraph. The disciplinary authority was not satisfied with the reply, decided to hold an inquiry. Full stop. The inquiry officer conducted the inquiry and held the charges to be proved against the respondent. Held the charges to be proved against the appellant. Full stop. On the basis of the report of the inquiry officer, the disciplinary authority imposed a penalty of dismissal from service by an order dated 25/3/2014. Right? Paragraph. The appellant thereafter raised an industry dispute. The labor court by an order dated 9/10/2015 held the domestic inquiry to be fair and proper, and thereafter an award was passed on 27/1/2016. By which reference was allowed in part, directing the corporation to reinstate the appellant without back wages and continuity of service with terminal benefits. Full stop. Paragraph. The aforesaid award passed by the labor court was assailed in a writ petition by the corporation. The learned single judge, by an order dated 23rd of April 2021, has allowed the writ petition. In the aforesaid factual background, this appeal has been filed. Paragraph. Learned counsel for the appellant submitted that the departmental inquiry was initiated after an inordinate delay of 34 years. Yes, 87, 14, 34 years. Inordinate delay of 24 years. Full stop. Paragraph. We have considered the submission made by learned counsel for the appellant and have perused the record. 22 years. 22 years, not 24. 22 years. We have considered the submission made by learned counsel for the appellant and have perused the record. Full stop. The learned single judge has placed lands on decision of Supreme Court in R. Vishwanath Pillai versus State of Kerala 2004 to SCC 105, as well as another decision of Supreme Court in Chairman and Managing Director FCI and others versus Jagdish Balram Bahira BAHIRA and others 2017 bracket close 8 SCC 670, and has held that the production of fake caste certificate by an employee does not entitle him to seek any relief. Paragraph. Admittedly, in an inquiry, the charge leveled against the appellant that he had produced the fake certificate at the time of securing the employment have been found to be proved. Full stop. It is not the case of the appellant that the findings recorded by the inquiry officer are either perverse or based on no evidence. Full stop. The only ground on which the order of dismissal has been assailed is that there was a delay in initiation of inquiry. Full stop. Full stop. The appellant had played fraud. The appellant had played fraud and had produced a fake transfer certificate in which his date of birth was incorrectly mentioned. Full stop. As soon as the aforesaid fraud was detected, the disciplinary as soon as the aforesaid no full stop. The aforesaid fraud was detected by the corporation on receipt of a complaint on 18/7/2009 against the appellant, and thereafter an inquiry was conducted. Full stop. Thus, there is no delay in initiation of inquiry in the facts and circumstances of the case, as the same has been commenced immediately after detection of the fraud played by the appellant on receipt of the report. Full stop. The full stop. The conduct. Full stop. The charges against the appellant have been found to be duly proved. Full stop. The appellant, therefore, in the facts and circumstances of the case, is not entitled to any relief. Full stop. The learned single judge has rightly dismissed the writ petition. Paragraph. We do not find any merit in the has rightly allowed the writ petition. Full stop. Paragraph. We do not find any ground to differ with the view taken by the learned single judge in the result. Appeal fails and is hereby dismissed. Yes, Mr. Krishnamurthy. That's all. Yes. No, it's all right. Yes. So only the two submissions, right? Delay of 25 years, and second is that your father participated in the proceeding before the land tribunal.
Statement has been very clear. Activities have been done. There was something about is a clear as well as his weight brother. Absolutely, there is no document. The land reform act.
Yes, yes. Claiming that there is an agreement to the favor. And that thing was contested and super difficult. And when the person claims that he is an agreement holder, he cannot claim that he is a tenant. That one has, but at that point of time, he has restored. He has also filed an application. Armed with a threat, land occupancy rate is granted. Immediately after the disposal of the family petition, but the date of disposal of the is taken into consideration. There is no delay in filing the petition. So have you said somewhere, right, that there is no delay in contention?
Same day. Petition was also remanded. They filed, making a amendment in the petition, they filed a petition for the outbreak. So they have also filed here. Technically, they have added to carried out with
No, but why do you say there is no delay?
performed with respect to a particular portion of the property. And in respect of the payment of the portion, but who was, but the 348 of 88, OS 48 of 88. That is which yes, what is 348? This is only 348 in this is 348. The two was before on 22 2005. That really
You first explain the delay, I mean, and then whatever you want to give. What he, as we have told you, Mr. He has raised only two contentions. That challenge to the order of land tribunal belated after 25 years. Number two, father having participated in the proceeding before the land tribunal, there was no need for remand. Your father had examined one witness also, and land tribunal passed an award. So there is the learned single judge who have dealt with the matter. What is the first explanation why it is not delayed? Because he filed a suit. He filed a suit. But that has nothing to do with the order passed by the land tribunal. No. Order of the land tribunal was passed. You were required to challenge it. Because why we are asking you is that probably there is no explanation to the delay caused in filing the writ petition. 2-5. 2-5. So that's what we are saying.
Not appreciated with the landlord because he says, I'm the landlord. I have never taken the property to my son-in-law, who is not a tenant at all. And all the revenue required. That will be a thing. He has been cultivated. And the up to the order passed, very landlord, all the RTCs were in the name of Basappa only, not even there. No revenue entries were in there, nothing, no documents were in there. And taking advantage of the relationship, he filed a farm number 7. And the authorities, the land people, just based on his own statement. Yeah. Yeah, the respondent. Therefore, we better reduce. Saying that he came so well to write a school, saying that opportunity right. He interested the matter, not in fact, and who was the teacher before of immediately by see the activity that good. There are two aspects. In case, especially in case of agrarian relationship, agriculture. It is a beneficial relationship. And what it really is a talent. That is not place is going to take it. But they are related, partition has taken. They have been allotted to me. And after 1981 also the artists were changed in my name, we are in possession. These things were there. Yes, certainly is made for Christian father. He is the landlord. Okay. And the respective subdivision. The people has not is made for two aspects. One is the statement of the witnesses. The same person, that has not been taken into consideration. First, the present doesn't put and that is not divided by that. We are not written to us, see order. Not a detailed order, we demanding. There is all these things are not there. Maybe for the reason that this is. Because our irrigation has been very little. We want to go for all these things, they are not taking order. The evidence has not been. You're the owners. If the land is taking the pass of minutes. That has not been done. Both PCs are absolutely no reasoning at all. The order at page 165. Before the signal on 2021 that he cultivating the opposite land from the last 20 years and pay Vara to the Vara not be and the respondent brave you to the respondent goes to past time. In another page he responded that before the tribunal on 27th and 18th that he remaining cultivated the land and not the picture as a very clear.
May not be necessary. You read the statement of your witness. Your witness. Your witness has said he is in cultivation. Your witness has said that he is in cultivation. statement of Basappa. And Basappa did not choose to challenge the order. And he was alive even at the time of filing the writ petition. He died after that. Whatever it is. Whatever it is, he did not choose to challenge the order. During his lifetime, only writ petition is filed. He was not even made as a party, though an allegation is made that he did not participate and not give a statement, etc. Actually, it is against the records.
Relationship that's on the other hand, there is speaking maybe one decision. The reason for decision in detail. Yes, alone, PCR. Page 50. Everything again.
Page.
Page 50. It is the attention, page. What answer that? Property is not. There is a mistake in the order. Because of the. That's not correct. It is attention. Maybe a mistake. Yes.
55.
In the taking the explanation is not. They have given some explanation and that was allowed in the amendment. The same day he allowed the repetition.
Have I got a permission to mention, my lord?
Yes, Mr. Rao.
In the next matter, my lord, I have been told that I have not filed my, it is ready. I will file it tomorrow. Your lordship may fix a date, any date, day after tomorrow or any date.
What date?
Next Monday, your lordship may have it filed finally.
Okay.
Or any date, even in this week, my lord, I am prepared to argue it.
All right, Monday.
Yes.
Appearing on behalf of
Senior
respondent number
counsel
1.
for the appellant submits file case synopsis during the course of the week. List on 9th of January 2023.
Much of that.
After what? How many years? 10 years? No possibility. Huh? What 2 weeks? Tomorrow it is listed. Tomorrow we'll come to you. Will come to know. Let it continue in the list, Mr. Deshpande. We'll take it up day after. What is there? Let it be in the list. Why hurry to get an adjournment? No hurry. So tomorrow you will come to know what has happened, right? Let it be 2013 matter. Huh? That's the thing. Don't say that. Donate counsel for the apparent praise for adjournment. This on 9th January 22. Hey, you don't want us to sit after the break? Huh? Which case?
67.
So
Reporting certificate.
when do you want? Direct counsel for the parties jointly pray for time to enable them to report settlement. List on what date? 11th January 20. $72 is family court. 72 is MFA. Family court. Huh? No. Other side is not there. Come at 2:30.
It's empty.
Huh?
It's empty.
What you-
35.
what have you done? You told them you're not sitting. Huh? No.
Number 68. DJ Soumya, yes, ma'am. Password 69. Please enter the evidence. 70. DJ Srinivasan.
You were saying something. Yes, please. What you want an adjournment? Ah.
About 20, 30 years. By operation, they are separate. The new development of taking place, APTCL itself has written to the government to regulate the and they could require this is the code. And there is a committee which is formed for see what they can do with regard to this regularization of the investment. So in that point of view, I thought if you finally granted it to the put a prayer into the report.
Who appears for respondents?
Hare Krishna Kolla.
Mr. Yes. Any idea?
Government.
You are not even attentive to what is being said about you, right?
Not a party.
Not a party.
They are not.
Ah. What to do? You want an adjournment, right?
The committee has been formed. They are considering the. In some way,
Learned counsel for the appellant. Mark his presence, none for respondent. Learned counsel for the appellant submits that during the pendency of this appeal, the KPTCL has formed a committee for considering the cases of regularization of the appellants. He therefore prays for and is granted 2 weeks time, 3 weeks time to enable him to apprise this court with regard to the decision which may have been taken by the aforesaid committee. Yes, list after 3 weeks. He has not come. Why? The day when the number is called, he is not present, and we are busy, he comes. Where is he?
Swami Gowda. Sadashivappa.
Yes, madam.
Sadashivappa.
What is it? Yes. Wife is the appellant. Decree of divorce has been granted on the ground of cruelty. So what have you done? What cruelty? What is the alimony which you are seeking? How much? Huh? Five crores? How much you are seeking? 5 crores? Huh? Here for permanent alimony. 25. Means, what is this thing? 24? 20th 11 2005. Date of marriage. And parties are living separately since 27/1. So his income is 2 lakhs per month.
Do you need 5 crores to make a living? Why do you need 5 crores to make a living? Whatever it is, see what? You have said that he has got that much property, this much property. This is not a partition suit. Question is the need.
At least we will.
No, but he says that his income is 1,17,086 rupees. Payslip has been attached with the affidavit. It's not 2 lakhs. But
2 lakhs also. What is the 5 crores? She's working. She's working. What is your salary? What is your salary?
678.
For you are having an earning. Only thing is the son's future has to be safeguarded. That's it.
Oh, it is said that you own 2 buildings with 10 rented houses. properties in prime locality in Bangalore. Recently constructed 2 houses. One is some site has been gifted to you. Is it correct? So you have, so what is the amount which you would this thing need for your son's expense education? So total is 62 lakhs 49,000. Right. So in para 4 of your this thing affidavit, dated 14/10/2020, you have said 62 lakhs 49,000, right? Now, what's the age of your son? Age. Come here. So, madam, how much permanent alimony will you pay? So how much will you pay? That's why we ask you, right? Relax. Wait. I mean, she would require, have you gone through para 4 of the affidavit that she says that she would incur an expenditure of 62 lakhs 49,000 on account of education of your son, and you are saying 10 lakhs. All these, read para 4, madam. All details have been given.
In your affidavit, you have said that he intends to pursue engineering. And now you say it is medical.
And he wants admission in management quota seat, right? Also, so that's why that only can explain 5 crore. Huh? So, like you will, what is this thing? Dermatology. He wants to become a dermatologist, right? You should have said that he wants to become a dermatologist. And see, it is how much? 2 crores. Dermatology. Madam, you have to be reasonable, right? Any this thing, any amount. Huh? So you have also to contribute. It's not that he alone will do it, because that no, we are not saying that he is not required to incur. It's not that he alone will bear the expenses. It's not that you also have to contribute, right? Is he not your son? Then have you gone through para 4? So she has given us this thing, all amounts and this thing, expenses 62 lakhs. Okay. Madam, your client draws a salary of 1,17,000, right? 86 rupees as per your own affidavit. How many dependents on him? The only son of his parents. Huh? And you don't have any other sibling, like
Your parents do not own any property. Your parents do not own any property. You have. Therefore, they are not depending on you.
not dependents on you, right?
And on the other hand, you are enjoying the rent from their property. Don't tell that they are your dependents, therefore. That they have produced or not, it is not the question. Whether you have been receiving rents or not.
So therefore, the 10 years. Huh? What have you done for your son? You tell us till today. Till today, what have you done? She has brought up the child and he is aged about 16 years. She is incurring the expenditure. What have you done as a father, madam? Nothing. Arguing here that I don't want to do anything. How this is possible? He is after all your son. So how can you at these days? No. So for expenses of this thing, no, she alone cannot handle. What have you done? So the only 30 by 40 site, you give it to a child. So will he become a doctor by owning a site 30 by 40? Yeah, no settlement after 10 years. What is the settlement?
Only the question of alimony.
Alimony. So that's why we have asked you to file a statement of assets and liabilities, right? So there we have to decide that question. We don't need your consent.
You are not denied about the receipt of the rent in your statement of objection. And you say that you are not receiving. You are not said even you are not said so in your objection.
This is the time to find out whether or not you have filed objections. What have you said? Huh? This is the time to find out what have you said. So it has been filed. So from there only we are finding out that you have said that your income is 1,17,000. So according to you, how much expenses would be incurred in son's education, supposing if he wants to become a doctor? And what about he's still 11th? He's a student of now, he's in 11th, right? Which petition? No, you have filed a petition seeking dissolution of marriage, right? we are dealing with the petition under section 25. So that's why you have been directed to furnish this thing, your assets and liabilities. Oh, no.
Application is pending since 2020. Even after 3 years, now you want again time.
You are getting HRA allowance of 57,000 and special allowance of 46,000. In addition, it's nearly 2 lakhs, madam. Your salary is 2 lakhs per month. PO Mahindra 2009 model. So you don't own any immovable property, right? But your income is above 2 lakhs. 1,17,086 is the monthly income. HRA allowance and special allowance 57,000 and 46,000. That is above. That means above 2 lakhs you are earning.
That is easy.
He's in. And you have admitted you are a manager in a company. Yes, madam. Did you pay any sum towards to your son? No. The question is, did you incur any expenditure? Then now your son is 16 years and you have not contributed anything for his upbringing. How this we can accept a situation like this?
When have you gifted that? When have you gifted the property?
No. So what? No. So for how much amount you had purchased the property? So, and for 53,000, you have taken a loan of 18 lakhs to repay. What are you talking about, madam? You have said in your affidavit. No, be clear. And don't this thing make factually incorrect this thing. This contains a declaration that it will be an offense. Be careful about it. We don't know. We are looking at your affidavit only and telling you. You have said that 18 lakhs and 10 lakhs you have taken loan. You have purchased the plot for 53,000 rupees. What is the school fee of your son? Is it 53,000? For the whole, will he incur 53,000 for the whole of his expenses? What are you talking about, madam? So therefore, the application should be rejected. This is the argument. Then, how can you argue like this? You are the father of that child. How can you argue like this that she has not made any application? So therefore, her application should be rejected. What ground it can be rejected? An application under section 25? You cannot run away from your responsibility by. So you are saying 10 lakhs? What is it? 10 lakh mean? No. We don't need your this thing consent of your respondent. You have filed, madam, statement of this thing. Capacity means means who will know? We have to determine how much he has to pay. And that is being done on the basis of your affidavit. You earn rupees 2 lakhs per month, or rupees 2 lakhs per month. You have declared it. And then how can you run away by saying that I will pay 50,000? Nothing.
But has not come is
You said he hasn't come. No. He told us that you haven't come. All right. Oh. No, you told us he hasn't come. So we were surprised to see him. Okay. Pleasantly surprised, not pleasantly surprised. Okay.
You text
Yes.
him. You text him and you should have told him, don't come to the court.
Yes. So what is it, madam? What basis? 5 crores? I mean, we don't understand what basis. How have you made a computation of 5 crores? What future requirement? So what is, how much of amount according to you? Yes.
The income and the use of tax. About the son. Is concerned on the minimum we can rent. Son's future, either we have to rent permanent amount or yearly education expenses, whatever is the expense. That is, you don't know that. She has said of the engineering. Now she says. Or he may be an advocate.
How much it can? What is that case, madam? Citation of that judgment where which says party should file statement of assets and liabilities. What is it? Citation? Get it? SSC online?
SC 90. SC
903. What's the criteria for grant of permanent element?
So five, so E. Suddenly, what is the quantity? Yeah. Yeah.
Para 77. Para 77.
77.
7.
Maintenance.
It's good. Anything permanent element.
Of the previous paragraph. Ensure that the dependent spouse is not reduced to regular.
Yes. Just balance must be drawn between these 11 factors.
So,
It must be realistic and reasonable.
Personal expenses, he has said 50,000. And 50,000 supposing for parents also. Is 1 lakh.
11 lakhs of service years. 6 lakhs, 50 lakhs.
Yes, madam. Her age is 49. It's 40. Okay, 40. So your husband would work for another 11 years, right? He's 49 years of age. He's 49, right? Respondent. 49. So what is the, I mean, eventually we are asking you repeatedly, you have not told us how, what is the basis of 5 crores? Or just, it's just a figure. We are trying to understand the rationale. How have you arrived at 5 crores? Or just like that, I mean, you have put some figure, it could have been 11 crores also. No, that's right, but that does not justify the amount. What is the basis of computing 5 crores? We are trying to understand, right? What is the basis of 5 crores? So,
Therefore, you admit that yourself. Therefore, you admit that yourself. You are not able to give an explanation for that 5 crores. Whatever possible, I have said.
Even
You have no responsibility, therefore. And what is it? If you have got any affection to your son, you should have paid it voluntarily. Why a maintenance petition has to be filed? Why should a maintenance petition be filed if you have got responsibility to pay to your son? It's only when you deny such payment an application has to be filed. If you are responsible, it is not required to be filed. Because you contested it. Because you contested it. Therefore, you did not come forward to pay. They are talking about the son. He might have left, she might be earning everything correct. What about the son? Why did you not volunteer to pay to your son? But he needs some maintenance.
So they are, what they have given admission to your son free of cost, not incurring anything. Somebody is sponsoring your son's education. What is it? What loan, madam? You can't run away, right? You have to be reasonable. We understand that you have to defend your client, but simultaneously you have to be reasonable. How can you run away from the responsibility of maintaining your own son? Will he not require any expenses? You are also living in the society as a person. You tell us, supposing if your son wants to become a doctor, how much of expenses would he incur? Tell us. You also know. You are a part of the society. You know what is. How can you run away by saying that their DV petition has been dismissed? As we repeatedly, third time we are telling you, we are deciding the petition under section 25, which is necessitated on account of your petition for dissolution of marriage. You tell that she has remarried, we will dismiss.
Studying in PUC now. What is this marks in 10th standard?
You told us he is a brilliant student, right? Huh? What are the marks? Great.
Yes.
All right, thank you. Anything else? Okay. Huh?
But you did not tell this what is the amount, final amount. If you have expressed to her, you should have told it to the court. What is the final amount?
After it is 10 lakhs, you jump to 20 lakhs like this. Huh? Let's see.
Then if you have spoken to 20 lakhs, then why did you make a submission that your party is ready to pay 10 lakhs? You are awarding 50 lakhs. 50 lakhs as permanent alimony and 50% of the future education expenses you are required to meet.
72, right, madam?
Hemant Kumar Ji, Shankarappa.
73. So
74. K. Narasimhan,
We have passed it over. Please wait. Which case 74?
74, K. Narasimhan,
Huh? 5 weeks time. 9 years, 10 years, 2030. What is it? Who has filed this appeal? Huh. The marriage has been dissolved on what ground? Guilty. Nothing. You have been sitting in the since morning, right? You are sitting in the court since morning. Whatever afternoon. So what did you do sitting here for about an hour? Please argue. Nothing 2013 matter. No inconvenience. Do you have any inconvenience? No. That's why you are here, right? Are you? It's all this 10-year-old case. So we will dismiss it then. Don't appear. Tomorrow then. And don't come if you don't have any instructions. We will dismiss. Come ready or otherwise don't appear. Tomorrow.
75, Nagaraj, 20.
Yeah. Yeah. What? So he knows that he will not get well within a week. Then why? I mean, what is it? No, that's fine. But does he know why he needs a week's time? You are representing. Make up request. Prayer for adjournment.
I can't deny.
The rate count. We don't know the rate count. Mr. So and so states that the arguing counsel is unwell just on 9th of January 2023.
Number 76.
76, my lord, I'm appearing for respondents counsel.
My lords, 76, my lords, in this, the appellant's counsels, my lords, it's been informed that recently the petitioner appellant has died, my lords. We will have to make necessary steps to bring a loss on record, my lords. Kindly a short accommodation may be granted, my lords. Rangama has been, she is deceased, my lords.
Mark the presence. He stated at the learned counsel states, Mr. So and so states that the appellant has expired. He therefore correspondent is granted a week's time to enable him to make an application seeking substitution of a loss of deceased appellant.
Grateful, my lords.
Pass over matters. 23. Kenneth Kumarji.
I appear for the petition in the.
I appear for the workman in both the matters.
Ready?
Yes, madam.
Yes. Where is the count? Is the appellant?
Yes.
DJ Somayaji.
Yes. Whether he will start or I will start.
Who has
I
filed
have-
the appeal?
My lord, in the first matter, I am the appellant. In the second matter, he is the appellant. It arises out of the order passed, my lord. The learner single judge has modified the order, or the portion of the order, page 31. Petition is allowed in part. Order of labor code is modified, directing the petitioner to pay ₹1 lakh to second respondent as compensation in lieu of reinstatement and back wages. Fail to comply, award 2 months compensation to any person until payment. I have filed the appeal so far as the payment direction is payment of 1 lakh is concerned.
So 1 lakh, Mister, in lieu of reinstatement and this thing compensation.
Yes, my lord. My case is there is no evidence regarding that he has worked for 240 days in a year. Para page 17 of the order. My lord, in that view of the matter, almost 6-8 sentences from below. That view of the matter, it cannot be but be said that there was some evidence let him be second respondent.
Yes.
Right. Work for 240 days in a year.
Yes, Mr. Naik.
Yes, my lord. The finding of fact by the labor court on the second occasion. Twice, my lord, the matter was adjudicated before the labor court. First time, my lord, they did not appear. Therefore, my lord, the matter was remanded. After remand, my lord, after appreciation of evidence, especially, my lord, exhibit W1 to W11 to W12, It is clearly established. Lordship may kindly turn to page 98. Page 98, you lordship may kindly turn to. Paragraph 7.
Yes, paragraph.
These documents, the requirement of continuing 40 days. From 61 as assistant cook. When he was returned, my lord, without any notice, without complaints of section 25 of Labor Court holds, it is a clear case of termination via ab initio. Granted reinstatement 50% back wages. Then a single judge held, my lord, that at this length of time, instead of granting reinstatement, granted for that, my lord, then a single judge referred to a decision of the there was delay in raising the 1986 by the government. 98 itself, government made the reference. There is no delay in raising the dispute. I approached the concession officer at the earliest point of therefore, not in the restatement 50% remanded because the employer said, my lord, that we are not no opportunity. After hearing what is adjudication takes place once again, and another award is passed, holding the reinstatement 50%. In fact, my lord, my plea was now, my lord, his age is 58 years. 58 years. So therefore, my age is 58 now, as on today. So considering that, my lord, there's at least at least to that, my lord, the next single
What is aged
of
about
time, no reinstatement.
He is dead. That workman is dead.
The compensation is only 1 lakh. No reinstatement. Compensation of 1 lakh is to the legal heads. No, there is no reinstatement, my lord. The question is, my lord, this compensation, even though, my lord, the next single judge should have granted little more compensation. I have regard to the fact, my lord, that I have been prosecuting.
When has he expired? When has he expired?
Yes, my lord.
When has he expired?
My lord, I'll give you this.
By 920.
5920 and 50% this thing. Wages. What would have been the amount? What was his salary?
Single judgment is 2013. Yes.
What was his salary?
My lord, he was drawing, my lord, the daily wage of 39 rupees at that time, 1996.
He was drawing how much?
1996.
39.
Rupees 40.
40.
You are working as assistant. He is one of the benefit of this 40. They were paying it less than the minimum wage.
We are not able to hear you.
What is?
Well, now, my lord, am I audible
yes.
now, my lord?
Yes, yes. So what was
What
his
happened, my lord?
monthly salary?
Apart from the
monthly salary.
Morning, I could not.
Monthly salary, Mr. What was it? Monthly salary?
No, 40 rupees was his salary.
Per day.
1,200 or 1,300 rupees. Plus, my lord, he was given free boarding and lodging. Considering that, my lord, his salary would be around 600 rupees at that time. 1 lakh is a very meager compensation to the workman, now to the legal heads.
Please.
Salary he says 600. Huh? 500. 6,000 rupees a year. How much period? Yes, now.
Page 46, my lord, he said it's for 500 per month.
Now, same thing I'm saying. I said it less also.
Mr. How is it multiplied by 24? What is the like multiplied by 24? $44,000. 1,44,000. 1,44,000.
9% interest for the 10 years is
Salary is 500 per month. That means 6,000. 6,000 from 98 to 24 years.
This is 1,54,000. Now 1,09,000 for interest. They will get now 1,90,000.
So what is the amount, Mr.? 1 lakh with 9% for a period of 24 years.
No, not 24 years from date of order. That is October 2003, nearly for 10 years.
9 years.
Take it 9 years.
9.
81,000.
80. All right. Anything else?
Therefore, my only prayer, my lord, that the compensation should have been higher, even if.
Yes. Okay.
Yes.
Compensation paid already is more. This is according.
Yes, sir.
Because there is no evidence
And my lord,
actually. He has not been appointed by the competent authority.
1 year 9%.
that is there, but
All right.
only special that his workman is no more. For information, my lord, whatever order your lordships are going to pass, then must be some time limit, my lord, otherwise, yes.
Yes. Time limit. All right. Thank you.
Yeah, 12,960 per year. 9%. 12,960 per year interest. Into 9 years. 1,16,006 part. Interest.
2.50.
It's 9% per annum. 9% per 1 lakh means 9% per annum.
1,44,000. 1,44,000.
9% interest means how much?
1 lakh. Only 1 lakh.
3 years.
9.
9,000.
9,000.
9 into 9 it is 81,000.
1,44,000.
61,000. Make it 2 lakhs.
All right. Yes. Thank you, Mr. Naik.
Yes.
WA number 6501 bar 2013 and WA 6509 bar 2013. WA 6501 bar 2013 has been filed by Chief Executive Officer, Zilla Panchayat, Mysore. It hearing after referred to as the employer, whereas WA number 6509 bar 2013 was filed by the employee. Being aggrieved of the judgment dated order dated 8th of October 2013, passed in WP number 12389 bar 2009. Stop. Since common questions of law and fact arise for consideration in these appeals, they were heard together and are being decided by this common judgment. So it's a common question on account of commonality of issues. Right? On account of commonality of issues, both the appeals are heard together and are being decided by this common judgment paragraph. Facts giving rise to filing of these appeals in a nutshell are that deceased S. Krishnan, after referred to as the employee, was employed on a daily basis as a cook in Boys College Hostel, Mysore, for a period from 1990 to 1996. Full stop. However, his services were dispensed with without compliance, or he dispensed with in violation of Section 25-F of the Industrial Disputes Act 1947. Full stop. The employee at the instance of the employee, the dispute was referred for adjudication to the labor court. Dispute was referred for adjudication to the labor court. Dispute was referred on 1998 for adjudication to the labor court. Full stop. The employee filed the claim statement and examined himself. Full stop. The employer did not, despite notice, did not appear before the labor court. The labor court, by an award dated 28/2/2003, directed reinstatement of the employee along with 50% back wages from 2/5/1998. Full stop. The paragraph. The award dated, the aforesaid award passed by the labor court was assailed by the employer in a writ petition, namely WP number 13747 bar 2007. A bench of this court, by an order dated 22nd January 2008, remitted the matter to labor court. Stop. Thereafter, the After the employer adduced evidence to stop the labor court by an award dated 5/9/2008, directed the employer to reinstate the services of the employee along with 50% back wages. Full stop. Paragraph. The said award passed by the labor court was again challenged in a writ petition before the learned single judge. Learned single judge by an order dated 10/2013 modified the award and directed the employer to pay a sum of rupees 1 lakh to the employee as compensation in lieu of reinstatement and back wages within a period of 2 months. Full stop. It was further directed that in case the amount is not deposited within a period of 2 months, the same shall carry interest at the rate of 9% per annum till payment. Full stop. Being agreed by the aforesaid order passed by the learned single judge, the employer has preferred WA number 6501/2013, whereas the employee has filed WA number 6509/2013. Paragraph. Learned counsel for the appellant submitted that learned single judge ought to have appreciated that there was no evidence that the employee had worked continuously for a period of 240 days in a calendar year, and therefore the question of violation of section 25F of the Industrial Disputes Act does not arise, did not arise for consideration. On the other hand, learned counsel for respondent has pointed out that during the pendency of this appeal, workman has expired on 5/9/2020, and it is suspected that the labor court had passed a well-reasoned award on the basis of meticulous appreciation of evidence on record, and the same should not have been interfered with by the labor court, by the learned single judge in exercise of supervisory jurisdiction. It is further submitted that the amount of compensation awarded by the labor court is inordinately low. Full stop. Paragraph. We have considered the submissions made on both sides and have perused the record. Admittedly, during the pendency of the appeal, the employee has expired on 5/9/2020. Full stop. We have considered the submission made on both sides and have perused the record. Full stop. The labor court. Full stop. The employee in the proceeding before the labor court had exhibited had produced certain documents from perusal of exhibit certain documents. Exhibit W1 produced by the employee clearly from the document exhibit W1 produced by the employee, it is evident that the employee had worked continuously for a period of 240 days in a calendar year. Full stop. Labor court has also referred to the circular Exhibit Exhibit W14 issued by Zilla Panchayat Mysore, stating that the daily wagers appointed after 2/8/1994 on a weekly basis or a monthly basis should not be removed from service. Full stop. Exhibit P15 and P16, which are the proceeding of the Zilla Panchayat Mysore, also provide that daily wages, that the services of the daily wages should not be dispensed with. Daily wages who are employed, who are appointed after 2/8/1994, after 1794 should not be dispensed with. Full stop. The Labor Court has also referred the order dated 17/3/2001, Exhibit W21, order of the Zilla Panchayat, Zilla Panchayat Mysore, dated 17/3/2001, 17/3/2001. Full stop. On the basis of the evidence on record, the Labor Court has recorded a finding. Labor Court has recorded a finding that the employee was employed as a cook in government college hostel with effect from 1/4/1990 and had completed 240 days of continuous service in a calendar year. It was further held that his services were retrenched from 1996 in violation. It was further held that the services were dispensed with in violation of the circulars issued by the state government dated 13/10/1992, 24/8/1994, and instructions dated 29/7/1995, and in violation of Section 25F of the Industrial Disputes Act. Full stop. The Labor Code paragraph. The Labor Code, therefore, by an award dated 5th of September 2008, directed reinstatement of the services of the employee along with back wages, quantified at 50% from 2/5/1998 till the date of reinstatement. To stop. The learned single judge, however, by an order dated learned single judge, however, by an order dated 8th of October 2013, has rightly declined to grant the relief of reinstatement along with back wages. Full stop. It has further it has been held by learned single judge that relief of that if the services of a workman is dispensed with illegally, the relief of reinstatement with back wages is not automatic. Full stop. The learned single judge, by placing reliance on decision of Supreme Court in Rajkumar versus Jalgaon Municipal Corporation, 2013, within brackets, 2 SCC. No, not 2, bracket, 13 will be in brackets. 13 2 SCC 751 has held that compensation of rupees 1 lakh is sufficient. Full stop. The learned single judge has therefore directed that directed the employer to pay the compensation of rupees 1 lakh within 2 months, failing which the amount shall carry interest at the rate of 9% per annum till payment. Full stop. Paragraph. The paragraph. The order passed by the learned single judge is based on meticulous appreciation of evidence, material appreciation of material. The order passed by the learned single judge does not call for any interference in this intra-court appeal. Court appeal except the quantum of compensation, which is compensation awarded by learned single judge. The quantum of full stop. The relief of reinstatement with back wages. Relief of reinstatement cannot be granted as the employee has expired on 5/9/2020 during the pendency of the appeal. However, in the peculiar facts of the case, the amount of compensation is enhanced to rupees 2 lakhs. The aforesaid amount shall be payable by the employer within a period of 2 months from the date of receipt of copy of the order, failing which the amount shall carry interest at the rate of 6% per annum from the date it becomes due till payment is made. Line below. To the aforesaid extent, the judgment passed by the learned single judge is modified. In the result, appeals are disposed. Positive.
But 70, 71, you probably estimate.
Yes, Mr. Oh, we thought you are here, so you must be ready. Tomorrow, fine.
73, the Hemant Kumar ji, Tenkurappa.
This court has directed you to file affidavit. Don't want to file the affidavit regarding assets and liabilities. We will record it.
You have to file an affidavit, madam, 13/10/2022. There is an order. Once there is an order,
She's not willing to.
you are not willing to file an affidavit, right? Permits, there is an order, madam, something you have not filed an application for modification. You don't want to file, right? You don't want to file, we will record it. We'll say that you are unable to file an affidavit, right? That's good. What is it? Nobody is appearing for respondent. So it will continue in the list. Let's see tomorrow. Let it continue in list.
Adjourn. Tomorrow.